In this episode, we talk about how Arvind Kejriwal has been refusing the summons by the Enforcement Directorate. We also talk about the 4 astronauts who will be a part of ISRO's Gaganyaan Mission. But first, we talk about Fali Sam Nariman, one of the most eminent jurists of the country. Hi, I am Niharika Nanda, and you are listening to 3 Things, the Indian Express news show. On Wednesday, the 21st of February, Fali Sam Nariman, one of the most eminent jurists the country has ever seen, passed away in his sleep at the age of 95. Nariman, who left a remarkable imprint on international law, began his career in the same year the Constitution came into effect, a document he dedicated his life to defending. During his tenure, Nariman was involved in numerous landmark cases, the effects of which are still evident today. A legal luminary and a man of immense grit, Fali managed to uphold his principles even in the toughest of situations. To learn more about Fali Nariman, his work and his life, my colleague Shashank Bhargava speaks with Indian Express's Apurva Vishwanath in this segment.
Apurva, begin by talking about what is the reason that Fali Sam Nariman was considered such an exceptional jurist.
If you have to pick just one defining moment from Fali's long life, I think it is his decision to resign as law officer number 3 during the emergency. So when the emergency was announced, a day later, Fali gave his resignation. And this was at a time when there was a lot of fear, and legitimately so, about how the Indira Gandhi government would react. There would have been personal consequences. In fact, Fali also wrote subsequently in his autobiography that he had difficulty finding a house on rent because he had to vacate his government bungalow after that. So this act of courage, just to take a principled stand and not defend the government that imposed the emergency, I think is what stands out in Fali's career. During the emergency, not a lot of people did that. And even amongst the law officers, Fali was the only law officer to have resigned.
Yeah, and that was a very courageous act at the time. In what way can we see that reflected in other aspects of his career?
Yeah, so for someone as senior as Fali Nariman, he was never afraid to speak his mind, whether that is inside the courtroom or outside. Now, you may agree or disagree with his views on many, many issues, but Fali was always somebody who voiced what he felt, whether that was to the judges, whether that was in, public platforms, whether when he wrote for newspapers, he always spoke and many a times was the voice of reason in these conversations.
Right, Anupurva, let's start from the beginning now. Let's talk about his early years. He was born in 1929. This was a very different time, pre-independence. And we understand that his family was originally from Burma.
Yeah, so his father worked in Burma and was setting up a subsidiary of an insurance company there. And later they moved to India, and Fali did his schooling in Shimla, for example, and he moved around a fair bit. Then in Bombay, he goes to the Government Law College and he starts his legal practice in 1950, the same year that the Constitution actually becomes a reality. So the timelines of an independent India having its own constitution and Fali Nariman's legal career sort of go together.
Yeah, so in that sense, he was there from the very beginning.
Yes, he was there from the very beginning. And he's seen the evolution of this document in so many ways and has fiercely defended it over the years. And he began his legal practice at the chambers of the legendary Jamshedji Kanga. So Kanga's chambers was sort of this go-to place for a lot of Parsi young lawyers at that time. So Fali in his autobiography again describes that he had half a chair at Kanga's table. So he began his practice from there. He was more or less a commercial lawyer, like most people in Bombay are. So he begins as a commercial lawyer, and which is also why you see him later in life hold briefs for companies like the Union Carbide or Air India. And it's only after he moves to Delhi that his career takes a turn, putting him as the foremost constitutional lawyer in India.
Right, and he practiced in the Bombay High Court for 22 years. He moved to Delhi as a senior advocate in 1971, and then the next year, the emergency happens, he resigns from his post. And this is also the year when he became close to the founder of our newspaper, Ramnath Goenka. Talk about how that came about.
Yeah, I think that's not merely incidental, and his resignation in some way must have caused his friendship with Ramnath Goenka. At that time, when Ramnath Goenka was putting together a bunch of people who were fighting the emergency, Fali Nariman was one of those law officers as he resigned from the government, began his association with the Indian Express, and it has continued till his passing.
Right, and over the course of his tenure, he was part of a number of landmark cases. Talk about some of these cases and the role Nariman played in them.
So I think, the biggest imprint of Fali's career you would find in two sets of cases, in fact. One is, of course, what we call the judges' cases, the second, third, and the fourth judges' cases. This second judges and third judges case in 1993 and 1998 is what established the collegium system of appointing judges. So in both these cases, Fali represented the bar and in a sense put this idea into the judges' minds that you could have this innovative reading of the law where the constitution itself says, like we know, that the president consults the chief justice. And in these rulings, the court basically says consultation means concurrence, that the president cannot appoint a judge without the chief justice concurring to this. So this you can, in a large way, credit Fali for putting the thought into the judges' minds. He led the arguments in both these cases. And continuing that, in 2015, he also led the arguments in the challenge against the National Judicial Appointments Commission. This was Modi government's first big policy intervention. And it came right after they came to power in 2014. Fali led the arguments in the Supreme Court. And the Supreme Court, of course, struck down the NJAC as unconstitutional.
And this is also the case where he famously says that my client is the independence of the judiciary.
Yes, it was quite a dramatic scene because on the opening day, the judges asked, Mr. Nariman, who are you representing? He was actually representing the Supreme Court Advocates on Record Bar Association. But Fali looked at the judges, looked behind him. There were a bunch of lawyers standing, looked around and said, my client, my lords, is the independence of judiciary. And from there, he led the spirited defense. Again, you can agree or disagree with his views. Even Fali was critical of the way the collegium system functioned. And just last year, he wrote a piece questioning one of the decisions of the collegium. But the fact that it had somebody like Fali leading the charge against the NJC did play a huge role in the Supreme Court striking down that constitutional amendment.
And Apurva, since he played a crucial role in its formation, could you talk about how the collegium system has changed judicial appointments?
So before the second judge's case, which is 1993, the executive directly appointed judges to the Supreme Court. Of course, Fali was aware of the background that played out during the emergency where, judges were superseded. Judges who gave judgments in favor of the Indira Gandhi-led government were given precedence in becoming Chief Justice. So with this background in hand, the collegium system was devised as a tool to insulate the judiciary from political appointments. What we refer to in the American context as packing the bench. As a forewarning, the Indian judiciary devised a collegium system to ensure that what happened during the emergency does not happen again. But has it played out in the way that the judges envisaged? May not have been. But it is an answer to the question that they faced at that time.
Okay, so the Supreme Court collegium and the challenge against the National Judicial Appointments Commission is one set. What are the other cases that stand out in his career?
So the other set of cases that I talked about, it's the minority educational institutions cases. So I say cases, although there is one big judgment of an 11-judge bench in TMA Pai versus Union of India. This case traveled from a 3-judge to a 5-judge to a 9-judge and then an 11-judge bench. And then to interpret what the 11-judge bench said, we've had smaller benches. So I think over a decade, you've had this case go through multiple benches. Fali has led the arguments before every one of those benches. So that also, in a sense, is one of the trademark qualities, if you can say, about Fali, that if he took up your case, he would make sure you see the end of it. So TMA Pai, which was a case that dealt with the rights of minority education institutions and to the extent that state can regulate such educational institutions. So this is one big set of cases that Fali led the arguments for. Of course, there have been many, many other cases from issues ranging from president's rule to the interface between fundamental rights and the parliament's power to amend the fundamental rights. That is the Golaknath case, which famously dealt with the right to property. It is in this case that the court said that the parliament cannot take away fundamental rights. The parliament cannot abrogate Part 3 of the constitution. So for about 5 decades, you could have seen Fali in virtually every big constitutional matter in the Supreme Court.
Okay, so Fali Nariman had a long and industrious career. But apart from these significant cases that we spoke about, there were also some cases that he had regrets about. Could you talk about some of those cases?
I think 2 cases come to my mind. One is, of course, where Fali himself has publicly talked about, which is the Union Carbide case. This is the Bhopal gas tragedy case, and Fali represented Union Carbide. On some aspects, say, the quantum of relief that was eventually granted to each victim, Fali did have second thoughts about it later in his career. Some interviews later, he said that maybe he wouldn't have, liked to hold a brief for that part. The other case I can think of is Nargesh Mirza versus Union of India. This is the infamous Air India case where the national carrier amended its service rules, basically said that if air hostesses get pregnant or get married, they could be terminated. This is a case that, in fact, Fali won for Air India. In a conversation last year, because we recorded an interview with Fali on the basic structure in April last year, when we were talking about Nargesh Mirza, he in fact said that he may have not used the same language because the times have changed and his thinking also has changed on some of these issues.
And Apurva, talk about his colleagues, his fellow lawyers. What did they think of him?
So Fali is also part of this line of illustrious Parsi lawyers that we've seen in India, right? The bar at one point was either dominated by Bombay lawyers or lawyers from Madras. From Palkhiwala, Sirvai, Soli Sorabji, Fali Nariman was one of those big giants. So for a generation of lawyers, they looked up to Fali and of course learned from him. But in his later years, Fali did have the capacity to shape influence in the bar, which is why you see him appearing for the bar in, like I said, the judges' cases, right? The bar chose Fali to represent them. And Fali was also, I think, was aware of the weight his words carried. So, for example, when the press conference happened where 4 senior judges of the Supreme Court spoke against then Chief Justice Deepak Mishra, Fali did not put his support behind the 4 judges. He, in fact, famously said, lump it. Deepak Mishra will retire soon.
I don't want another 20 years later, some very wise man in this country blame that Chalameshwar, Ranjan Gogoi, Madan Lokur and Kurian Joseph sold their souls. They didn't take care of this institution. They didn't take care of the interests of this nation. All 4 of us are convinced that unless this institution is preserved and it maintains its equanimity, the democracy will not survive in this country or any country.
Of the 4, Justice
And Apurva, in that regard, what can we learn about the way he worked as a reformist?
Yeah, so if you look at the collegium cases, of course, Fali comes across as someone who is not afraid to bend the rules, bend the black and white letter of law to ensure that the institution is guarded. But on other things, he's been fairly an institutional guy. Like I said, the judges' press conference. Or even later, when it came to differences in the collegium, he largely thought that, and this is what he wrote also in his books and in his writings in the Indian Express, that the collegium would self-regulate, that there are 4 or 5 people and it's not one man who runs the institution, not just the Chief Justice. So in that sense, Fali has been fairly an institutionalist. But the common thread is that he looked at the larger interests of the institution at all times, whether that meant speaking up or whether that meant holding your breath for the time being.
And Apurva, what do we know about his last years? What did his life look like post-retirement?
I don't think he retired really, but 2018-19 onwards, you could say post-COVID, you've seen fewer appearances of Fali in court. But by then, his wife, Bapsi, also had passed away. So losing a partner of 70 years definitely took a toll on him. So in the last couple of years, you've seen fewer courtroom appearances, but that didn't shrink his space as a public intellectual. He kept writing, he kept giving these interviews, he kept speaking about what he thought was more important. In fact, his last book just came out a few months ago, which is actually a Know Your Constitution kind of a book.
Right, the exact name is You Must Know Your Constitution, and it was published by Hay House Publishers. But Apurva, during your reporting of the law, what kind of interactions did you ended up having with Fali Nariman?
Of course, many journalists, including me, have met Fali over the years. In fact, the first case I covered closely was the NJAC, which Fali argued. But my first interaction really with him stands out and says a lot about the person that Fali is. There was this case concerning President's rule in Arunachal Pradesh happening. This was in court 2 in the Supreme Court, and I think I went to court on the second or third day of the hearings. It wasn't one of those big cases or the case that would make a lot of headlines at that time. So when I went to court, I did not understand a lot of context of what was happening. And these were days where you couldn't take your cell phones into the courtroom. So I came out of the courtroom, and in the Supreme Court, there is a corner where near the parking where people stand and smoke. I was sitting on one of those ledges and, looking up the case on my phone and trying to read whatever I could. So I could understand the proceedings in court. Fali had finished his arguments and it was close to lunch break and he was leaving. He saw me on the ledge and first warned me not to sit there. Then I got off and, said hello. And I said I didn't understand or I didn't follow what he argued in the court. Then suddenly he's standing there for the next 40 minutes, gave me a masterclass on, the events of what led to President's rule in Arunachal Pradesh. I think he also forgot that it was his lunch break. Then he called his junior, took out his papers, his set of briefing papers, which had a timeline of events. There were so many characters in that case, from Nabam Rebia to Kalikopul, and Fali would then go on to explain all of these issues. And that this is, not too long ago. This is about 6-7 years ago. At that time, he was the biggest lawyer in the bar. And to be there and talk to a young reporter and basically explain about what this case really is. That's sort of what defines Fali Nariman for a lot of reporters.
And finally, Apurva, what do you think Fali Nariman will be most remembered for?
Fali Nariman, like everybody has been saying, will be remembered as the conscience of the bar, the conscience of the judiciary, which means he did not mince words. He spoke freely of what he thought. And he was very inclusive in his actions, whether that meant speaking up for minority rights, whether that meant eschewing the best practices of the bar, right? For example, we had his junior Subhash Sharma tell us when Fali accepted a brief, and if that case took about, say, 6 months, he would not take up other briefs because he thought he would dedicate his time only for that case and not be distracted. These things, this work ethic, this ability to speak freely, these things define Fali Nariman and perhaps his generation as well.
And next we talk about Arvind Kejriwal being summoned by the Enforcement Directorate. For a while now, the Enforcement Directorate, India's law enforcement and economic intelligence agency, has been attempting to summon Delhi Chief Minister Arvind Kejriwal. He is being sought in connection with the Delhi excise policy case. The Enforcement Directorate has issued its 8th summons to Kejriwal. He has been asked to appear before the agency for questioning on March 4. But despite having summoned him multiple times, CM Kejriwal has consistently refused to appear before the Enforcement Directorate. On Monday too, the Delhi Chief Minister skipped the Enforcement Directorate's summons and headed to Rajghat, stating that since the matter was before the court, which has asked him to appear on March 16th, the agency should wait for its order. Now the question is, can individuals simply refuse to appear before the Enforcement Directorate? And if so, for how long can they do so? In this segment, we speak to Indian Express's Deeptiman Tiwary about this. So, Deeptiman, firstly begin by explaining why the Enforcement Directorate has been trying to summon Arvind Kejriwal.
Okay, so Arvind Kejriwal is under investigation in the Delhi liquor policy case. Basically, we all know the background. Enforcement Directorate has accused the Arvind Kejriwal government of, having made close to somewhere 100 crore out of the Delhi liquor policy case by, granting certain favors to certain private players to cartelize the entire market.
Right. And one of the reasons why we are talking about this case is that Arvind Kejriwal has refused to be summoned by the Enforcement Directorate. And he has also cited certain reasons for it. So could you explain on what basis can one refuse to be summoned? Because one imagines the charges of money laundering are pretty serious and Enforcement Directorate is one of the top central agencies. So how is he getting around it?
All right. So ideally, one would expect that when an agency calls you for investigations, you must cooperate. That is how it should happen. However, Arvind Kejriwal has refused to attend interrogation following 7 summons. Arvind Kejriwal, in fact, has said that I have asked the Enforcement Directorate as to why are you not first specifying as to whether you're calling me for questioning as an accused or a witness.
And is that something the Enforcement Directorate is supposed to do? Are they supposed to tell you whether you are a witness or an accused before summoning you?
All right, so let's understand the provisions under which the Enforcement Directorate calls any person for questioning. These provisions come under Section 50 of the Prevention of Money Laundering Act, and the provision nowhere mentions that you have to make it clear as to whether the person being called for questioning is an accused or a witness. In fact, Enforcement Directorate officials say that it is not possible to do so because the investigation is underway, and only after the proper investigation is conducted and a person has been questioned can we decide whether the person is actually a witness or an accused, or probably neither. Person has no knowledge to even qualify him as a witness in the case. So they say that it is not possible. However, I must add that under CRPC there are provisions, although CRPC does not directly apply to the PMLA, where people can be called as witnesses or as suspects, and sometimes police in their cases do so. So, but those extent and specific provisions are not there under PMLA. And ED officials say that we haven't yet decided whether the person is a witness or an accused. So, how do we say that in our summons?
And Deeptiman, of course, we know that Arvind Kejriwal is a chief minister. But can you and I also do this? If the Enforcement Directorate summons us, can we just simply refuse to cooperate?
It's a very valid point because obviously, despite all checks and balances and provisions made under the law, the enforcement is done by human beings, and human beings can typically be hierarchical in their approach. So a common man can face different consequences than, say, a chief minister. For example, there have been cases, and I am aware of it, having covered Enforcement Directorate for many years. People have been picked up from their weddings for not cooperating with ED investigations. While they're getting married, they have been picked up from their weddings. So obviously, they were not people for whom there would be dharnas on the road or voices would be raised in parliament or assemblies or resolutions would pass. But at the same time, opposition parties have this grouse that ever since the Narendra Modi government has come to power, it has specifically gone after opposition leaders. And, no one from the BJP has ever been arrested. And they argue that as if, every BJP government or every BJP politician is completely clean. And this is a matter of record that, yes, it is true that more than 90% of politicians who have been foisted with cases or have been arrested or have been summoned for questioning by the Enforcement Directorate in the past decade are actually from the opposition. So they do have a point. However, the legal grounds and the merits of the case can only be decided by a court.
And so at this point, what is the way forward for the Enforcement Directorate? Can CM Kejriwal just refuse to be summoned?
Okay, so let's understand. So Section 50 of the PMLA says that, when the Enforcement Directorate calls you for questioning, you are bound to appear before it. So you cannot say that I will not appear. However, you can have problems like you may be unwell, you may be in the hospital, or there may be other issues in your life. Your daughter might be getting married or anything. So you have to respond to the agency, and you respond to the agency and you seek more time that, okay, fine, I am not running away from you. I have this problem. So I will come back to you. Don't worry. And the agency generally under normal circumstances, it does adjust to it and issues fresh summons. And in these cases also, fresh summons have been issued.
Okay. And then when does the Enforcement Directorate decide that enough summons have been ignored and now the person is not cooperating with them?
So let's understand that there is absolutely no provision in the law which defines what is non-cooperation with the investigation. So how many number of summons should be issued to a particular person before that person can be arrested is not there. Also, should a person be merely arrested for refusing to attend to ED summons? Again, the law is very clear. Under Section 50, there is absolutely no provision to arrest anyone for refusing summons. In fact, the only provision that is there under Section 50 to arrest a person is actually not in Section 50 but under Section 63 of the PMLA, which says that if a person refuses to respect the summons issued by the ED or refuses to produce documents or evidence as demanded by the agency, shall have to pay a fine, a penalty of 500 rupees or maximum 10,000 rupees for each default or failure. In fact, until this was there, so this was understood to be a toothless provision because, given the amount of money laundering that is involved, which runs into hundreds and thousands of crores, an accused can, every day pay that kind of fine, rupees 10,000 to ED and not appear before it. So later another provision was added which said that, if the person called for questioning refuses to respect the summons, then Section 174 of the Indian Penal Code can be invoked against the person. And under this, the person can go for up to 1 month in jail. However, for that, the ED would have to register a fresh case in a police station. Then that trial will have to be separately conducted and then the person will have to be convicted.
Yeah, which is tough because then an entire different agency is involved.
Yeah, so the whole legal process becomes very cumbersome and it's just very impractical. It's very difficult to implement. The other way is that if somebody is not coming, you get a non-bailable warrant issued. Now for that, again, you will have to go to a court and, convince the court that the person is willingly not cooperating and that the only way to question this person is by taking him into custody. So that is a very cumbersome process and not easy to do.
And Deeptiman, have we seen any such cases of non-cooperation in the past?
There have been such instances of non-cooperation with ED in the past, and generally they have ended in the arrest of the person after multiple summons. Or we have generally seen that after refusing several summons, the ED has either gone to the court or the person has finally agreed to respect the summons and appear before ED. So generally there is no escape from this. You have to appear before the agency. However, we must remember that the agency cannot just arrest because it feels that you're not cooperating with the agency. Because Section 19 of the PMLA, which deals with the powers of arrest of the Enforcement Directorate, is very clear that the Enforcement Directorate will arrest only if the investigating officer is convinced that the person it is going to arrest is guilty of the offense. So, in fact, this is a sort of a check and balance because police can arrest you merely based on suspicion. But Enforcement Directorate official has to have cogent evidence in his hand and record reasons in writing as to why the person is being arrested. So, it is very clear that non-cooperation or refusing summons alone will not tantamount to a cogent reason for arrest. And this has been held in court orders also, where the Delhi High Court on October 19, 2023, as recently as that, has held that Section 50 of the PMLA, under which summonses are issued to people, does not grant any power to the ED to arrest a person.
And in the end, we talk about the 4 astronauts selected for the Gaganyaan mission. Prime Minister Narendra Modi on Tuesday announced the names of the 4 astronauts who will fly to the low Earth orbit as a part of the Indian Space Research Organization's Gaganyaan, which will be the first crewed Indian space mission. PM Modi made this announcement while visiting the Vikram Sarabhai Space Centre in Thiruvananthapuram, Kerala. Group Captain Prashant Balakrishnan Nair, Angad Pratap, Ajit Krishnan and Shubhanshu Shukla have been selected for the job.
ये सिर्फ 4 नाम और 4 इंसान नहीं है, ये 140 करोड़ एस्पिरेशंस को स्पेस में ले जाने वाली 4 शक्तियां हैं.
They are all either wing commanders or group captains in the Indian Air Force and have extensive experience working as test pilots, which means that they are already trained to be prepared to respond quickly in situations where something goes wrong. The 4 astronauts have been undergoing training at the Space Agency's astronaut training facility in Bengaluru. The selection of the astronauts happened at the Indian Air Force's Institute of Aerospace Medicine. Only 3 of them will eventually go to space as a part of the Gaganyaan mission. The 4 astronauts were trained at Russia's Yuri Gagarin Cosmonaut Training Center from February 2020 till March 2021. American Space Agency NASA will also train an Indian astronaut for a mission to the International Space Station by the end of 2024, said the agency's administrator Bill Nelson during his visit to Delhi in 2023. The astronaut who will be selected will be one of the 4 people who are preparing for the Gaganyaan mission. The Gaganyaan mission will demonstrate India's human spaceflight capability by launching astronauts to an orbit 400 kilometers above the Earth for a 3-day mission. After that, they will be brought back to the Earth safely with landing in Indian sea waters. You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and produced by Shashank, Bhargava and me, Niharika, Nanda. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Audio and write to us at podcasts@indianexpress.com.